Hello everyone, today we're talking about New York City and how carrying a gun there is going to be presumed to be unlawful until proven lawful. Yeah, guilty until proven innocent. I don't know, maybe that just sounds wrong to me, maybe I'm wrong, let me know down in the comments. But today we're talking about how the Office of the Deputy Commissioner sent out a memo regarding concealed carrying firearms and how they are going to be considering it unlawful until proven lawful. Now, that just sounds wrong saying, I'm going to be very stuck on that, but it is something to unpack. We got a lot to talk about here. I'm going to be very critical of police right now, but before I do, I am going to give credit where credit is due. In the state of California, we just recently defeated temporarily SB 918, a bill that would basically ban concealed carry everywhere in the state of California. I did a video showing how the restrictions would prevent me from being able to carry pretty much anywhere in my city, and we talked about how that would be very bad. Well, that failed. My opinion, a huge part of why that bill failed to pass was because the Sheriff's Association of the state of California put out a memo talking about how this would be very bad for police departments everywhere, how this would cause huge increases, and they criticized its ability to change crime and how it criminalized good people from being able to lawfully carry a firearm. The police in that instance, the unions, the organizations opposing gun control, was directly responsible for this bill not passing. It had a simple majority. It needed 66% of the votes to pass because it would have gone into effect immediately. This bill will be reintroduced in the next session without the urgency clause, meaning it would only need 50%. Do I hope that the police show up again and say no to this bill? Yes. Is it likely that it's going to cause a less than 50% vote? Unlikely, but credit where credit is due. The police support opposing that gun control was successful. Now, I rambled on a bit, but in this bulletin from New York, basically to the New York Police Department, it's one of the big bullet points is, anyone carrying a firearm is presumed to be carrying unlawfully until proven otherwise. License holders are required to carry their license when carrying a firearm and must provide their license to law enforcement upon request. Now, a huge problem with this bill, the way that they've presented these laws and how they're going to be going into effect, is the addition of sensitive and restricted locations. On the list of restricted locations is all private property and all commercial property. Yes, all property, unless they put signs out front specifically saying that they will allow you to carry a firearm. So, by default, once this goes into effect, pretty much everywhere across the entire city of New York will be a restricted location, meaning that even if you have a concealed carry permit in New York City and you're in one of these locations and there's not adequate signage, you committed a felony. Now, the restricted locations list is much smaller. Conveniently, though, on duty, off duty, and retired police are exempt from this. Same thing for the sensitive locations. Now, the sensitive locations list is much longer, and it includes things like government buildings, hospitals, places of worship, public libraries, facilities where childcare, daycare, after-school programs, all public and private schools, all shelters for homeless, youth, or domestic violence victims. They want to disarm domestic violence victims. Now, maybe these centers for domestic violence victims are what would be considered a sterile location, like a court where there's plenty of armed security. Maybe. I'm not too hopeful for that. Adult care, nursing homes and assisted living facilities, public transportation, including the facilities where, bus stops, that kind of thing, or bus centers or train stations, that sort of thing. In or on the grounds of performing arts centers, theaters, stadiums, arenas, racetracks, museums, art galleries, amusement parks, banquet and catering halls, and casinos. Any location being used as a polling location. Any public sidewalk or public area that is restricted from the general public by access by a government entity for a limited time or for an authorized event such as a parade or other outdoor concert. Now, it says that signs have to be posted with plenty of time in advance for people to prepare for that. Maybe you miss those signs, very dangerous, right? protests and demonstration or marches. So if a protest is just happening and they happen to stroll by you and you weren't ready for it, congratulations, you're committing a felony, a Class E felony in New York City. Times Square, Times Square, pretty much the entirety of it. So in addition to police being exempt from the restricted, they will also be exempt from the sensitive locations. So even a retired police officer, someone who is not currently a police officer, but was at one point, would be exempt from these laws in New York City and would be exempt from being assumed guilty until proven innocent, which again, just in my mind, seems wrong. Maybe I'm interpreting this very negatively, let me know. But this is just a huge issue that we are seeing across the nation. New York is not going to be the last place. It might be the first place to enact laws like this in the post-New York State Rifle and Pistol Association versus Bruin case. But we saw, I believe it was the case where this was determined unlawful by a judge, but because the person that was a plaintiff in the lawsuit said some of the wrong things, the case was thrown out and the injunction was not granted. So we're seeing instances where the wrong plaintiffs for these court cases actually caused a huge issue, even though the judge admitted that this lawsuit was unconstitutional. But the lawsuit didn't have standing because the plaintiff was just the wrong person for the job. So I'm very happy that I am a part of the lawsuit Boland v. Bonta that is being put forward by the CRPA and Michelle Associates. That lawsuit, if we were successful, would be huge for allowing people to purchase any handgun in the state of California. Now, if SB 918 is reintroduced next year, I'm sure the CRPA would be the first to have a lawsuit for this kind of thing. I know that they were hinting at something like that on Gun Guy TV's channel, but it's important to understand that if you are a plaintiff for lawsuits or if you want to support organizations, you should support organizations that are putting the right people forward and presenting the right plaintiffs and the good cases. FPC has a lot of great cases. CRPA has a lot of great cases. If you live in the state of California, those are two great organizations to support. If you are wondering what you can do about this in your state, I highly recommend you get involved in your local state chapters, local state organizations. They're going to be the ones that are most aware, most involved in that kind of thing. Thankfully, 25 or 26 states are now constitutional carry, meaning that if you can legally own a gun, you can legally carry a gun. But California, New York, we are not so lucky. Let me know what you guys think about this down below. You guys know the drill. Have fun, be safe, stay dangerous. Peace. Again, I do want to say thank you to everyone that supports this channel. You guys know, likes, comments, subscribes, all that helps. Double check that you are subscribed. People do get unsubscribed. I know every time I say this, people say, oh, it's never happened to me, but I get way more people commenting that it has happened to them when I don't mention it for like a month or so. So double check that you are subscribed. Thank you.